Sometimes an often overlooked component of an estate plan among business owners is the appropriate use of a buy-sell agreement. Uh, those are not mutually exclusive terms when it comes to estate planning for business owners. For most people who don't have business interests, a typical estate plan consisting of wills, trusts, and powers of attorney may be substantial enough for a comprehensive plan. However, when it comes to business owners, we have to add another component to that because many times the largest asset in the estate is the business. It requires the majority of the time, the effort, and the money, and therefore is the largest asset as part of the business owner's estate plan. So we want to make sure that that interest is protected to the extent possible, much like all your other assets. And so the use of a buy-sell agreement when you have a business partner is a necessary component to a comprehensive estate plan for business owners. And why is that? Because things happen. Estate planning is all about dealing with incapacity, disability, death, special needs issues. And that's exactly what happens with buy-sell agreements. There are certain types of triggers. Basically what it is, it's a right of first refusal. It's the right of one business owner to be able to buy out the business from the other business owner at typically an agreed upon or an appraised value, thereby preventing either a spouse or an adult child or some third party from inheriting that deceased business partner's interest. And now you are now in business with a stranger, someone that you didn't bargain with. Why? Because you didn't properly respect what happens to that business interest upon your partner's passing or otherwise incapacity. Think about it. It's not just about passing. If your partner has an estate plan and they have a power of attorney for property management, who do you think is the person that's going to be exercising the power to vote the stock or the LLC membership interest upon the partner's incapacity? Well, it's going to be the agent inside that power of attorney. And who's that going to be? The spouse. If not the spouse, the adult child. If not Uncle Bob, if not their accountant. They may not know the first darn thing about running your business, but they're the ones that have complete control over that, in this case, incapacitated partner's interest. So you want to prevent that by happening. So here, that would be an example of a trigger of a buy-sell. Incapacity, long-term disability would be a trigger that would require that disabled or incapacitated business owner to sell, and you, on the flip side, are obligated to buy. That is a right of first refusal. Now carry that over to a death event. So here you have a death event. Now it becomes an inheritable asset. So here you want to make sure that you have the right to acquire that asset from now the deceased owner, because otherwise it could wind up in the hands of the spouse, among the children. It could wind up in probate and tied up with all the time, expenses, and delays of probate. So that's another issue you want to have. And the nice thing about, at least with a death event, typically most people would fund a buy-sell agreement with a life insurance policy. So there really isn't much point in creating a wonderfully crafted buy-sell agreement if you have no way to exercise that forced buy. Sure, there may be a forced sell, but how do you force buy if there's no cash involved? So many times with a death event, and from a disability point of view, we do use disability insurance policies. And so you have an insurance policy which brings an instant source of cash to be able to buy that interest from the surviving spouse or from surviving family's interest, which basically allows that to take place much, much more fluid. But in addition to disability and death, you have things like loss of citizenship. It may have an adverse effect on the corporation's S status for tax purposes. There could be insolvency. So the U.S. bankruptcy trustee may try to grab it. Involuntary transfers to a third-party creditor, a creditor claim coming in. Divorce is a big problem, especially in community property states or even in equitable states and in their common law states, where you may be 50% with you and your partner, but now that 50% interest of now your divorcing partner winds up being at the end of the divorce, maybe 50, 25, 25. And now you're in business with a 25% shareholder who may be particularly adverse to the overall situation. Or that 50% interest may be lost in the divorce as part of a divorce settlement agreement. So there again, so divorce is maybe another trigger. that we have loss of moral turpitude. So if an individual has resulted in moral turpitude issues, what happens to being a lot of bad press or bad PR to the company, that can be a triggering event also. So as you can see, these business assets and the estate planning are not mutually exclusive for our business owners. Because if you want to make sure that the business is there to carry on and survive the life events of your business partners, you want to make sure that you have the ability to grab that interest back so you can have it. And on the flip side, if you happen to be the incapacitated partner or you're the deceased partner, you want to make sure that there's a source of funds to be able to buy your interest and receive the cash. So your spouse can have funds and wealth replacement for now the lost income. It will trickle down to your family again as a source of wealth replacement as a result of your loss of income. So it's very important that we have it on both sides. So again, buy-sell agreements are a very, very important part of estate planning for business owners. So if you happen to be in business and you have a business partner, it may be very important, if you don't already have a buy-sell agreement, to get one, that for sure. If you have one, maybe have it updated and revised to make sure it kind of is a bit more comprehensive on its trigger events. We normally would find lots of improvements to a lot of off-the-shelf type of buy-sell agreements that you would get to find room for improvement on that. And also to make sure that it's gonna be there as advertised and work as the source of funds. Many times you have buy-sell, but they have been updated in years, and as a result, the underlying insurance coverage, the dollar amounts may be inadequate. So maybe some revisions to the source of funding. So here again, if you are a business partner and you're involved in estate planning, or maybe you visit us and haven't visited in a while, please consider giving me a call. My name is Brad Barth. I'm a partner here at BarthCalderon, where we plan today for all of your tomorrows. Thank you for your attention. Bye-bye.